the I'm the contractor because we had raised certain bills from the petitioner. Now there was a dispute in that case, and we had approached the
Okay.
facilitation council. The proceedings are undergoing that.
Oh, you're not the petitioner.
Pardon?
You're not the petitioner.
I'm not the petitioner in this case.
What has the petitioner?
The petitioner,
What
they
is the
had
case of the
released the bills.
I'm the one who floated it.
Yes. What is your case?
Lordship, their case is that work contract is not applicable under the MSME Act. So under that purview, they had come before your Lordship under 227 to challenge the entire proceedings. So now in the meanwhile, during the pendency of the entire matter, Lordship, the NBCC was the petitioner and he has released all the bills that we had claimed.
Okay.
So nothing survives. So your Lordship that directed me to approach the council and to withdraw the proceedings. So they are yet to pass a formal order.
Okay.
So once that formal order is passed, your Lordship, then your Lordship may close up the entire matter.
So,
Lordship.
and the petitioner will have no more case.
No more case, Lordship. Even I will have no more claims, Your Lordship, because my grievance has already been met.
Fine. On prayer made by the parties, this is matter to 1 week.
Lordship, with your permission, I humbly pray if a matter may be kindly listed tomorrow, Lordship. It's anticipatory bail, Lordship. We are in the process of filing. There are 2 bails, Lordship.
Fine.
Please, Lordship. Lordship, I beg to make a mention for item 7, Lordship. Lordship, in this matter, we're supposed to file written argument, Lordship, but Lordship, I'm praying for 1 week's time, Lordship.
2017 matter. You are the petitioner.
Yes, Lordship. Give us one week, Lordship. We'll be filing.
Yet again, the petitioner has sought for some more time to file the written argument. Though this court has given sufficient time for the same to be filed. On the preamble, the petitioner is directed to file the same within the next date fix. This is matter after 1 week.
Leo bless.
May I please your lordship, I beg to mention item number 15 that the conducting counsel senior advocate S.P. Mahanta is indisposed. So I pray for the matter to be listed after 3 weeks.
You are there?
Objection, your lordship. I'm for the state, your lordship.
Prayer has been made seeking accommodation on the ground that the Leonard senior conducting counsel is indisposed on grounds of personnel, on health ground. On the prayer not being objected, the same is allowed. This is matter after 3 weeks.
No, I oblige, your lordship. Daily cost list, item number 1.
This matter relates to challenging the reinstatement of the respondent, and same parties, he has filed a new writ petition, and Lordship fixed the matter on Wednesday, 13th of this month. That is Wednesday. So, and more of the council or district council is not there. So my pre-matter will be taken up after a week, since the Lordship is going to consider the matter on Wednesday, other matter.
On pre-made by the council petitioner, list this matter after 1 week.
Your Lordship, can it be after 10 days? Because after a week I'll have some and Wednesday or Thursday.
After 10 days.
Yes. Good. All right.
Item number 3.
Lordship was pleased to call the medical report on the last.
The report is given. Page has been tagged. Last page. And, the accused person has been shifted to civil hospital, my lord, Shillong. Have you given you a copy?
My lord, one more limb of my argument apart from the medical condition, my lord, if lordship allows me to argue that. My lord, here, my lord, the statement of the co-accused is very important. Now, here what has happened, my lord, I am just a helper of a bus. The co-accused has confessed to the fact that he was approached by some people to bring this contraband to Shillong. And some people were supposed to receive it from here, and he was supposed to be paid a certain amount of money. Now, my lord, nowhere does my name figure in the entire scheme of things. My lord, I am just a helper in the bus. There is a driver, there is a co-driver. 3 people have been arrested.
See, Mr. Pratham, you know very well. Firstly, you are obstructed by Section 37.
Absolutely, my lord. That I am aware, my lord.
Number 2, presumption has to be drawn,
My lord.
and the the fact that conscious or constructive possession principle has to be taken into account has to be there. That those are only, you see,
Absolutely, my lord.
they are a matter of evidence.
That limitation, I
Even eventually, if you are found innocent, then so be it.
My lord, it's commercial quantity, 1.85 kg.
that is there. My lord, the rigors of 37 will definitely be there. But only thing here, my lord, is that, my lord, I suffer from a serious ailment.
Yes.
Now, my lord, if I am allowed to go on at least on interim bail, my lord, I will make my relatives stand as surety. My lord, if there is any such fear that I'll flee or anything, my lord, at least allow me to at least recover, and then, my lord, I will face trial. But only to satisfy, my lord, if lordship, I'll just take lordship to page 14 once. My lord, this is the statement given by the co-accused, my lord. I'll just read it out once, my lord, just to satisfy, my lord, that perhaps this person has been in the wrong place at the wrong time.
Even so,
My lord.
even so, not even going to the statement of the co-accused, even if he implicates you, see, that would not stand.
Matter of evidence.
Absolutely, my lord, but he has not even implicated me. He has said that, my lord, it is him. He implicates himself only. He says that he was just the co-driver. He did not even call me. Somebody else called me, and then 3 of us came in the bus. If I'll just take, my lord, to page 14 only once, if lordship allows me. I'll just read out the statement, my lord. This is the statement of the co-accused. 14 of my bail application.
Yes.
My name and address is stated as above. I am married and I am a father of 3, 2 girls and a boy. I am a drug user. I use such and such for the past 10 months, and I had got myself checked up for addiction, in which I was registered in PHC, and I am on OST medication. Before becoming a bus helper, I worked as a cook in Paragon, Kerala in the year 2016 to 2017 for 2 years. Then I returned back home in Manipur and started working as a daily wage labor in the locality. In the year 2022, in the month of June, I was called by one driver to help him as a bus helper in the night super passenger bus bearing registration number such and such. Usually every month we go to get around 2-3 trips Manipur Shillong. On 14/11/2022, one person known as Ashiv came and met me at my house and offered to transport some illegal contrabands, in which I rejected, but he offered me money in return and gave me rupees 500 per showcase, in which I agreed. On 16/11/2022, he came along with one lady and bought the consignment, in which we loaded in the rear seat of the bus, and told me that he will pay up after the consignment has been delivered, and he directed me to drop the consignment at ISBT Mayong, Shillong, in which the party from Shillong will come and pick up the consignment. Hence, on 17/11/2022, I was at home and Mohammed Iqbal Hussain came and called up Saddam Hussain. So, my lord, I am Saddam Hussain. My lord, I do not have any direct link with the co-accused, my lord, who has confessed to the guilt, my lord. So, Mohammed Iqbal moved the obstructing truck while Saddam was making way for the bus.
After the bus was moved, we left in about 100 meters. Then we stopped for buying cigarettes, gudka and water. Then we left, in which Mohammed Iqbal drove the vehicle, and we reached at Impal at BOC for picking up the passenger. And then the counter person gave the money for the expenses of the trip. We left at 10 a.m. and after that we had lunch at Check Mile and left. And after crossing Assam Gate, we stopped at Karbi Anglong for tea, and then we left and stopped at Dabo Ka for dinner, and we proceeded ahead with the journey until we were detained by the police. On being checked by the police, I was the one who opened the lock of the rear seat where the consignment were kept. So, my lord, this is the statement of the co-accused, my lord. So, perhaps, my lord, of course, the rigors of 37 will still lie, my lord, I will concede. But the fact remains that, my lord, I am not directly involved. So, my lord, if there is no such direct involvement, my lord, that even in a commercial quantity, my lord, the court can grant bail, my lord. That is my submission, my lord. Presumption will come, my lord, if at least the foundational facts are there, my lord, even prima facie, even at in the face of the charge sheet. Recovery has been made in the bus, my lord. We three were there. Other passengers were also there. Now the co-accused says that I was the one who was contracted by a third party to deliver the drugs. Now I was called by another person. I have no direct link with the main co-accused also, my lord. My job was just to help the bus driver, just to change. Maybe when he gets tired, then I drive the bus. And this person, the one who actually is involved, was a helper of the bus. So that is the case, my lord. Otherwise, my lord, at least medical bail, my lord, so at least I may at least get myself treated properly, my lord.
But you've been referred to civil hospital.
Well, my lord, I will not be able to get proper medical treatment over there. My lord, when it comes to UTPs, my lord, I have seen, my lord, never any proper medical treatment is given. And this person can't even walk properly, my lord. He has to be carried to the hospital in Nagpur. The only issue is, my lord, if his nerves are damaged to such an extent, my lord, he may get paralysis of the lower back, the entire lower back.
Yes, Mr.
My lord, medical report is already there. He has been given proper treatment, my lord. He has been referred to Shillong Civil Hospital.
6 to 7 times he's been in and out of the hospital, my lord, whenever from the time he was in custody. If he was given proper treatment by now, my lord, perhaps there would be signs of some, my lord, recovery. But his situation is getting worse. His condition is getting worse.
In the report, my lord, somewhere it says that the medicine is not responding. He is not responding to the medicine.
Mr. Pratham, Leonard Counsel for the petitioner. Also heard Mr. Edson Kon, Leonard GA appearing for the state respondent. On being directed, Leonard GA has produced the medical status report as regard the medical condition of the accused person, Shri Saddam Hussein. On perusal of the said medical report, it appears that it is seen that the patient, the accused, was referred to civil hospital and is now undergoing treatment at civil hospital Shillong. However, the Leonard J has fairly pointed out that in the said report, there is an indication by the concerned medical officer stating that the patient, the accused, is not responding to conservative treatment or
medicine, not responding
to the medicine. In normal circumstances, this court would prefer that the accused be treated at a government facility, and direction was also given that he should be given the utmost care. However, considering the condition of the patient accused, it would not be fair if the relatives of the accused are not given the opportunity to take care of their relative or ward, for which he may be referred to any private medical institution. Be that as it may, without going to the merits of the facts and circumstances wherein the accused was charged with, though the offence under the NDPS Act are indeed grave and serious in nature. However, on medical ground, the prayer of the petitioner is found reasonable. Accordingly, the accused Saddam Hussein is hereby granted interim bail for a period of 2 months to enable him to get proper medical treatment at any medical facility of his choice. He is, however, to be bound by the following condition: that he shall not abscond or interfere with the process of interfere with the court process, including tampering of evidence and witnesses, that he shall report his movement to the court concerned. IO is no longer, matter has been charged sheeted to the court concerned every fortnight, fortnightly. That in case he is required to move to be treated outside the state of Meghalaya, prior permission of the court is required for the same. That he is required to give his contact number or the contact number of his relative or guardian to the court concerned if he is to be contacted at any point of time. If he is required to be contacted at any point of time, that he shall bind himself on a personal bond of 50,000 with one solvent surety of like amount. Let's calculate 2 months from today. Today is 4.
11 November.
11 November.
10 November.
That he shall report to the correctional home on 10th November. The above petition is hereby disposed of.
Alright.
Item number 5.
Yes.
Please, Your Lordship, for respondents 1 to 5, Your Lordship will be filing it during the course of the day, Your Lordship. The affidavit is ready, Your Lordship. Will be filing it during the course of the day.
What about the other?
Respondent number 6, my lord, I'll require another 2 weeks time. I've just entered appearance on
You are the same.
same, the resigned, the former same.
Former. And who's respondent 7?
Sir, I'm appearing appearance, Lordship. We have filed our affidavit.
Doesn't seem.
Oh, you have just entered appearance.
No, we have filed our affidavit.
You have filed?
Your Lordship.
Miss Sina Cloud and counsel for the respondent KHADC, that is 125 respectively, has submitted that the counter affidavit may be allowed to be filed in course of the day. They allow. Mr. Piliman Nongri, letter counsel for the respondent 6, has however wait for 2 weeks time for the affidavit, counter affidavit on behalf of the respondent 6 to be filed. Allow. The respondent 7 has reiterated that the counter affidavit on his behalf has been filed. In view of the above, this matter is adjourned. List the same after 2 weeks.
Item number 6.
Praying for some time. The concerned person, my lord. Because he was busy last week, my lord. We met for a very brief time. So if
2016 matter, Mr.
My lord, by next date we'll finish it, my lord.
This was hard, Lordship, because the only issue my friend has raised that regarding the
Applicability
constitution of tribunal as per the RT rules,
And
whether the government has constituted a tribunal or not. So far as the applicability of the rule, I am also, because that rule is RT is applicable to all the schools, irrespective of aided or government, all. That is only the issue is whether tribunal has been constituted, because that rule says that the state government will formulate a tribunal.
But I had disputed the applicability of the Meghalaya School Education Act, since it is an SSC school. So my lord, because he requested me, because last week he was busy, probably some Lok Adalat was also there.
That issue, I don't think that, because I am also saying that is applicable to all the.
What are you saying is not?
Yes, ma'am. No, not with regard to RT rules, my lord. With regard to the Meghalaya School Education Act.
So what you are required is
Lord, I was to take full
file
instructions.
the instruction.
Lord, he has requested because last week he was very busy.
Mr. KP Bacharji, GA, appearing for the state respondent, has submitted that the instruction sought for could not be elicit from the concerned official, as he was preoccupied with official duty and could not. So it is therefore prayed that some more time may be allowed for the instructions to be received and to be placed before this court accordingly. How long? 1 week?
Lord, may I prefer 2 weeks so that I don't pay any further time.
2016.
That is there. However, we'll finish on the next date.
Let's do it.
Malad.
Whether you get or not, we'll
Malad.
hear the matter finally.
Malad.
In fact, Mr. Sheikh said that has been heard.
Malad. In fact, it was heard at
Now
length.
you just have to refresh the court on what has been.
Because my only issue there so far as the conduct rules and service rules and conduct rules is concerned, because RT rules nowhere prescribe the conduct rules. So far as the applicability of the rule is concerned, I am also admitting that rule is applicable to all the schools, primary and upper primary.
On primate, this is matter for 2 weeks.
Matter will be heard.
Hello.
Item number 8.
My lord, this matter, my lord, pertaining to ACP and MSCP, my lord was pleased to pass an order for filing a rejoinder, my lord. My lord, considering the petitioner is in remote area in Manipur, my lord, so he could not. I pray that 3 weeks time may be given, my lord.
Mr. Counsel for the petitioner has submitted that the petitioner. Who is the petitioner?
My lord, he is a DS1. He is a serving personnel of Assam Rifle, my lord.
Being a serving personnel of the Assam Rifles, is now presently posted in Manipur, in the state of Manipur. Therefore, he could not be contacted as far as the preparation and instructions with regard to the rejoinder affidavit to be filed is concerned. Accordingly, it is prayed that some more time may be allowed for the said rejoinder to be filed. How long?
3 weeks, my lord.
On pre-made, this is not up to 3 weeks.
I'll have it. My lord, even item 9.
Same.
Same.
Same, I mean, he's also in Manipur.
Manipur.
Fine, same order.
Item number 10.
Yes, what is this?
It is a lordship. Lordship, this is a matter where petitioners have challenged an order of the Lokayukta. Petitioners are absent. Evidently, my lord, my feeling would be that they have lost interest in the matter because of lordship's order passed in the division bench, Hewinson Sangma case, where the same grounds of challenge had been adopted. Lordship was pleased to hold in the division bench that those grounds are no grounds at all. They took that to the Supreme Court. Supreme Court also didn't interfere. So possibly there is nothing much left in this case. Subject to what the petition.
You are for the petition? Yes, tell me.
I'm waiting for my sending your lordship is coming.
If they are ready, we'll
If they're ready, we can wait.
Fine. Another vote.
Item number 13.
But here we have to file the additional affidavit, my lord. It is ready. However, my lord, the district health and medical officer will have to come from Tura, my lord. So I'm praying for little time.
Mr. KP Bacharji, GA has submitted that the additional affidavit could not be filed today on the ground that the what is the excuse?
My lord, the district health and medical and health officer will have to come from Garo Hills, my lord. So he was not unable to come, my lord. So I'm praying for little time.
On the ground that the deponent is posted in Garo Hills and could not be contacted and is not able to come to Shillong for swearing of the said affidavit. Is therefore prayed that some more time may be allowed in this matter. 1 week?
My lord, 1 week should do.
On pre-made, this matter is posted after 1 week.
All right.
Item number 16.
Yes, Mr. Joshi, tell me.
Please, Your Lordship, the only issue that is left is with regard to the amount, Your Lordship. Because during the pendency of the said writ, Your Lordship, the respondent, they have already paid us
Yes,
1,96,000.
Guru, you are in this case. Are you or not?
Devnath, Mr. Devnath is.
Okay, you are not for Mr. Devnath?
Yes, Your Lordship.
But he is not here.
I don't see.
Oh yes, his name is here, but he is not here.
Now we
Yes,
are
tell me
only agree with
what is the matter about?
Your Lordship. Now we are only agree with the amount, Your Lordship.
No, amount
Because
tell me
what
the
we are
tell
claiming
me
is
the facts of the case.
Your Lordship, what has happened is that the petitioner has challenged the compulsory retirement, Your Lordship, and he succeeded in that writ, Your Lordship. And as per that order, Your Lordship, he was supposed to receive the entire back wages, which he received, Your Lordship. We have admitted that fact also. Your Lordship, after receiving of all the retirement benefits, Your Lordship, he was supposed to receive the increased rate of pension, Your Lordship, whereby the respondent has asked him to submit his previous pension payment order, Your Lordship, and the same was submitted before the concerned department, Your Lordship. He submitted his PPO, and a fresh PPO was issued to the respondent, Your Lordship. Page 47, Your Lordship, annexure 2. This is the fresh PPO issued to the petitioner, Your Lordship. If Your Lordship may kindly come to page 48, Your Lordship. There they have written, Your Lordship, area of pension with effect from 1st 2007 to 30th April 2013, amounting to rupees 6,97,429, which was due to the pension to be which was due to the petitioner, Your Lordship, in this case. Out of this amount, Your Lordship, the petitioner has already received the amount of 3,52,000, Your Lordship.
Okay.
And after deduction of that amount, Your Lordship, the petitioner was supposed to receive 3,98,000.
So the balance.
Yes, Your Lordship. And out of that balance also, Your Lordship, after filing of the instant writ case, Your Lordship, the respondent has paid 1,96,693 to the petitioner, Your Lordship. So the balance amount what we are agitating as of now is 1,21,952. That should be paid by the respondent authority. And Your Lordship, this calculation, it's not mine calculation.
No, if that is the case, then you have you made any communication or representation?
Yes, Your Lordship. Before coming to the Honorable Court, Your Lordship, I have filed representation.
What is that?
They never reply to those representations, Your Lordship. If Your Lordship may kindly come to page 60 to 61, Your Lordship. My representation,
yes,
Your Lordship. After that, Your Lordship, we have received the reply from the account officer, Your Lordship. That was from Central Pension Accounting Office, Your Lordship, directing the respondent authority to that is, Your Lordship, at page 65, Your Lordship, whereby the respondent authorities were requested to take up the matter of the petitioner, Your Lordship. Your Lordship, this calculation are not mine, Your Lordship. Even the respondent authority themselves, they have given us the entire calculation, Your Lordship. If Your Lordship may kindly come to page 50, Your Lordship, annexure 9, Your Lordship. Page 50, Your Lordship.
Yes.
At last G, Your Lordship.
Yes.
JC number so and so, bill number so and so. The amount is reflected as 6,97,429, Your Lordship. That is the amount which we were claiming, Your Lordship, and out of that we are accepting the fact that we have received those amount, Your Lordship, what the respondent authority have paid us, and the only balance amount what we are yet to receive is 1,21,000. Because unless we file this instant writ, Your Lordship, the respondent authority, they never give any heed to the representation or anything we filed before them, Your Lordship. Only after we filed the instant writ, Your Lordship, they came up paying this amount, 1,96,000, which they are saying that is the actual amount which they are supposed to pay. And why affidavit in opposition, your lordship, they have brought certain documents by which they are saying that the petitioner is supposed to receive that amount only, 1,96,000. They themselves, they are disputing the fact, your lordship. Initially they gave us that calculation, we relied on those calculation, your lordship. Based on those calculation, we were made we received those payments, your lordship, and now they are saying that that is not the actual amount. So my grievance is only, your lordship, that
then how do you ascertain
yes, your lordship,
what is the exact amount, or
yes,
how was the calculation made? See, because you see, in all fairness,
yes, your lordship,
it could be a mistake in accounting.
yes, your lordship,
It could be because of some certain rules and
yes, your lordship,
regulations, or it could be that you are indeed entitled to this amount,
yes, your
but was not given by them. So you see, you have to ascertain those facts.
yes, your lordship,
If it is incumbent upon them to pay, they'll have to do it.
yes, your lordship,
But if they have come up with certain explanation,
yes, your lordship.
then if it is reasonable, you should accept that. You
That's
understand?
what, your lordship.
If
Till
it
now,
is
whatever
reasonable,
they
then
have paid, we are accepting to that.
But we are
Though
talking about the balance
yes,
amount.
yes,
So if this amount on their, after their, I don't know, I have not got
yes,
the papers. If after calculation it is found that no, you are no longer entitled to this amount
yes,
because of, like I said again,
yes,
certain calculation, miscalculation, or whatever it is. So you have to be fair to them.
yes, your lordship,
But if it is done arbitrarily,
yes, your lordship.
just because they don't like you, they don't pay.
That's what.
So in that case, of course, you have a case.
Yes, your lordship.
So how do we ascertain that?
If your lordship may kindly grant me some time so that I'll just calculate those, and if the petitioner has any calculation to that extent,
Yes.
I'll bring before your lordship, your lordship.
And Mr. Devnath, you have to.
Your Lordship, here in this case is saying there's no response is given. Even in his writ petition, Your Lordship, page 67.
Forget about the response. See,
So-
now, Mr. Devnath, what is required? You have heard what
Yes.
this court has, comment.
Yes, Your Lordship. So here, Your Lordship, just come to my affidavit, page 23.
Page 23.
This is the statement, Your Lordship, due drawn statement.
Yes.
This is prepared even prior to filing this petition, Your Lordship, and this statement I've given, and then it is total amount due 5,15,477.
Where is it?
And this page number 25.
Okay, 5 lakh.
5,15,477. $25 in the consolidated in the next, you will see.
Okay. Yes, I've seen it.
Then this already paid 3,18,784. Net amount paid 1,96,693, and this has been made payment through his account.
This 1,96,000 was also given.
Already paid in accounts.
See, Mr. Rishi.
Yes, your lordship.
This statement
Yes, your lordship.
is always always found reliable.
Yes, your lordship.
Because in accounting process,
Yes, your lordship.
even for us or any standard person, you get this kind of
Yes, sir.
calculation. And like I said again, more often than not, this is accurate.
Yes, your lordship.
And it was calculated with effect from 1st January 2007
Yes, your lordship.
till 1st April 2013.
Apparently, there, you will see, there was mistake earlier calculation.
Mistake, yeah, I think mistake was on their part. When they have issued that statement.
And this is given, you will see, in his writ petition is given page 67. This has been informed prior to filing this writ petition.
Because
And his
initially when the petitioner he had approached the respondent authority, your lordship, what they said was that they don't have the entire service record of the petitioner. And during the pendency of the instant writ, your lordship, they have come up with all the calculation now, your lordship. So
like I said, if,
Your
if,
Your
the,
Lordship,
if,
I'll
the,
just seek
if the
instruction
calculation is
from my
not correct,
yes, yes, Your
nothing.
Lordship.
I mean, we can't go against facts
Yes,
and
Your
figures. I think this looks very, it looks reasonable to me.
And moreover, you see this in my affidavits I given, when these calculations come and payment was not in a position to make payment because of his contact number and account number was not available. And subsequently,
as far as he is concerned, like a majority of the amount has been received by him, so that's not a problem. Whatever has been stated in your statement must have been given to him. Perhaps if you calculate,
yes, Your Lordship.
This amount of 5,15,000 must have been given to you.
Yes, Your Lordship. This amount I have received, Your Lordship. I'll just seek instruction from the petitioner, Your Lordship. What exact amount he has received?
Otherwise, what happens?
Yes, Your Lordship.
Even if the respondent gives you whatever amount, even on their calculation, if later on it transpired that it's a wrong calculation, you have to refund the same.
Yes, Your Lordship.
It becomes more burdensome.
Overpaid amount that has to be refunded, and
that is
at any
rule.
point of time, if they have overpaid us, then in that case they'll come back with us only, Your Lordship, saying that, agitating that you repay those amount what have been repaid.
So why should you take that trouble? 1 week?
I'll just 2 weeks, Your Lordship.
The counsel for the petitioner has submitted that he may be allowed to seek instruction as regard the calculation of the amount due and payable to him, and also the amount that was already paid to him by the respondent authority. On premium matters list this matter after 2 weeks.
Oblige you.
Second call, item number 10.
May it please your Lordship. Well, this is an application under Article 26 of the Constitution of India, whereby we have changed the order of the Lokayo.
Excuse me.
If my Lord may kindly come to the impugn order.
All the respondents are here. Who's respondent 4? Because you are the complainant.
Yes, they are the complainant, my Lord.
Please.
Page 92, my Lord, Annexure 5 is the impugn order which is under challenge before this Honorable Court.
Yes.
My Lord, may kindly come to para 3, my Lord. The following facts are material for consideration in this matter. Respond number 2 to 15 are contractors. There being no government servant, do not come under the jurisdiction of Meghalaya Lokayuk Act 2014. The first point is this, my Lord. The person who is before this Honorable Court is a contractor, my Lord. The Lokayuk can exercise jurisdiction only over the respond number 16 to 18, who are the government servant. Now, the government servant are not before this Honorable Court, my Lord. The huge fund to a tune of 100.71 crores was allotted to Garu's Autonomous District Council as special assistance during 2015-16 for development of areas under the 6th schedule in Meghalaya. In the sanction letter dated 29/9/2016, it was provided, among others, that while spending the fund, strict adherence to the guideline issued by the Niti Aayog should be followed. It was also provided that the Garo Hills Autonomous District Council should submit utilization certificate
Along with work complete report, etc., the respondent authority has submitted a utilization certificate, work complete report, etc. But from the inquiry report, nothing could be ascertained as to whether the Niti Aayog guidelines were followed or not. Now, my lord, I will pause here. They are saying, my lord, that the report has been submitted. The completion report was also submitted. But whether the Niti Aayog guideline was followed or not, my lord, it is for the person who has conducted the inquiry to find out. My lord. Then they says, my lord, the details inquiry report submitted record in its finding that as a result, rampant corruption and misappropriation of public fund by the contractor and officers of GADC in executing of projects 31 plus 4 under Williamnagar constituency, the evidence on record did not substantiate the alleged allegation made, my lord. They are saying, my lord, this allegation which was made against of us, my lord, it was not made out, my lord, in the report, my lord. Now, further, my lord, it says in page 93, if my lord may kindly come to page 93.
Yes.
If my lord may kindly come to para 3, my lord.
Yes.
Coming to execution of work, it is relevant for the inquiry report that in many scheme plan changes were affected without disclosing any reason. Transparency in the matter of selection of contractors seemed to have not maintained. There are other things related to the execution of work which could not be examined by the inquiry officer. This could be possible only in the inquiry to be made by the department. Therefore, it is expedient and proper to make more elaborate inquiry by the department concerned. So now they are saying that it is for the department to conduct the inquiry, my lord. Because as per the inquiry of the Lok Ayukt, my lord, nothing has come up, my lord. Now they also says, my lord, they have due to lack of jurisdiction over the non-government servant, person like the contractor as mentioned earlier, and other legal hurdles in the greater interest of the public and for doing justice, it is directed that. Now, my lord, here I am aggrieved with, my lord. If my lord may kindly see para serial number 1, my lord, the complaint petition be treated and registered as FIR under the proposed sanction of law and investigated by the local police under the supervision of the additional SP Williamnagar, my lord. This order was, my lord, this order was challenged before this honorable court, my lord, and Justice More, my lord, he has stayed this order, my lord, because it was unjust, my lord. Now, my lord, may kindly see the law. To what extent the Lok Ayukt can pass an order, my lord. My lord, may kindly see page 53, my lord. Chapter 7.
Yes.
If my lord may kindly see section 2.1.
Section 2.1.
Yes, my lord. The Lok Ayukt shall, on receipt of a complaint, first decided whether to proceed.
Is it section 20 or 2?
21, my lord. 20, section 20, clause 1, my lord. The Lok Ayukt, on receipt of a complaint, first decide whether to proceed in the matter or close the same, and if the Lok Ayukt decide to proceed further, it shall order the preliminary inquiry against any public servant by its inquiry wings or any agency to ascertain whether there exists a prima facie case for proceeding in the matter. Now, my lord, Lok Ayukt, first when a complaint is filed, the Lok Ayukt has to see, my lord, whether there is a prima facie case against the allegation which has been made out, and if there is, then they will proceed with the matter, my lord. So, first thing, my lord, he has to apply his mind that whether prima facie case is been built up by the complainant or not, my lord. Second, my lord, may kindly see subclause 3, my lord.
Yes. Yes.
What he can do, my lord. First, before I go to clause 3, my lord, I will take to my lord to clause 2, which is also very relevant During the preliminary inquiry referred to in subsection 1, the inquiry wings or any agency shall conduct a preliminary inquiry and on the basis of material, information and documents collected, seek the comment of the allegations made in the complaint from the public servant and competent authority, and after obtaining the comments of the concerned public servant and competent authorities, submit within 60 days from the date of receipt of the reference report to the locayak, my lord. So within 60 days they have to submit a report, my lord. And report was submitted. On the basis of the report, my lord, they said there is no case, my lord, made out. But however, for the end of justice, they have said that the complaint petition to be treated as an FIR. Now whether the locayak has that power to do it or not, my lord. Now, my lord, may kindly see clause 3, my lord. Page 53, clause 3. A branch consisting of not less than 3 members of the locayak shall consider every report. Now, 3 member has been amended, my lord, to 1 member. That was challenged, but this honorable court has not intervened, my lord, in this matter. Under subsection 2, from the inquiry wings or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case and make recommendation to proceed with one or more of the following action. So, my lord, whether there is a prima facie case, and if there is a prima facie case, my lord, the following action he can take, my lord. My lord, may kindly see page 54.
Yes.
Investigation by an agency. What he can do, my lord? He can ask further investigation by an agency, my lord. Second, my lord, initiating of the department proceeding or any other appropriate action against the concerned public servant by the competent authority. Third, my lord, closure of the proceeding against the public servant and action taken to proceed against the complainant under section 47. If the complaint was found to be false, my lord, then action should be taken against the complainant, my lord. Now, my lord, here the inquiry which was conducted, they did not find out anything, my lord, against us, my lord, against the petitioner especially. An inquiry was supposed to be dropped, my lord. Now, my lord, the locayak, the chairperson, my lord, has said, my lord, for the end of justice, but the law doesn't permit you to do that, my lord. The law only says, my lord, that either to initiate a department proceeding or any other appropriate action against the concerned public servant. I am not even a public servant, my lord. So where the FIR will come from? Now, my lord, he has referred this matter that this entire petition should be treated as an FIR and the additional SP to supervise the matter, my lord. My lord, may kindly see again the impugn order. The impugn order says, my lord, that my lord, in the inquiry report, if my lord see the order, the inquiry report is not with us, my lord, it is they are supposed to produce if required, my lord. They said, my lord, the impugn direction are issued even after the inquiry officer found that there is no rampant. No rampant.
Where is that?
My lord, may kindly see para 4, my lord,
Para 4,
of 92, page 92, my lord. Again, my lord, I will read out the same thing, my lord. The huge fund to a tune of so and so was given as a special assistance during the period during 2015-2016 for development of the areas under 6th schedule in Meghalaya. In the sanction letter dated 29/9/2016, it is provided among others that while spending the fund, strict adherence to the guidelines issued by the Niti Aayog should be followed. It was also provided that the JHDC should submit utilization certificate along with the work completion report, etc. The respondent authority has submitted the utilization certificate, complete work completion report, etc. But from the inquiry could not be ascertained as to whether the Niti Aayog guidelines were followed or not. The details inquiry report simply record in its finding that as a result, rampant corruption and misappropriation of fund by the contractors and officers of the GDC in executing so and so, the evidence on record did not substantiate the allegation made. So the report says, my lord, that the allegation which was made, my lord, that 2031+4 project, which was supposed to be carried out by the contractor, my lord, there is no evidence on record substantiating the allegation made, my lord. So, my lord, there was nothing, my lord. And misappropriation of fund by the contractor and officer of the JGC in executing of the project. The direction seemed to have been issued while spending the fund. Strict adherence to the Niti Aayog guidelines were not followed. However, in this regard, my lord, there is no reference to the inquiry officer. What they could have done it, my lord, this was a preliminary inquiry. After the preliminary inquiry, they could have sent it for the further inquiry, my lord. They have not done it. They said that there is no evidence or material, so let an FIR be registered. But the law doesn't permit, my lord. Law allow only three things to be done by the Lok Ayukt, my lord. Is in page 54 again, my lord. I will take, my lord, to page 54.
Yes.
Investigation by any agency, initiating of the department proceeding or any other appropriate action against the concerned public servant by the competent authority. Against the public servant, my lord.
Yes.
And the third is closure of the proceeding against the public servant and take action to proceed against the complainant under section 47. Now, my lord, may kindly see section clause 7, which is very pertinent.
Yes.
This is relevant in connection with our case, my lord. What should have, if there was a prima facie case against of us, my lord, in the report, what should have been done by the Lok Ayukt, my lord? A branch consisting of not less than 3 members, again, my lord, 3 members will come to 1 member, of the Lok Ayukt shall consist every report received by it under subsection 6 from any investigating agency and may decide as to file charge sheet or closure report, either to file charge sheet or closure report before the special court against the public servant, initiate the department proceeding or any other appropriate action against the concerned public servant by the competent authority. No, I am not a public servant even, my lord. I am mere a contractor. Where is the question of FIR? Whether the Lok Ayukt has been authorized by this act to direct to file an FIR, my lord. This is not permissible. As per clause 7, my lord, is very clear. File charge sheet or closure report from the special court against the public servant, initiate a department proceeding or any other appropriate action against the concerned public servant by the competent authority, my lord. This is very much apparent and very clear, my lord, that an FIR, the Lok Ayukt cannot direct for taking into account the entire complaint as an FIR, my lord. So, my lord, that is why, my lord, I am praying before this honorable court to set aside this order, my lord, and pass appropriate necessary direction, my lord, on this. I'll reply, my lord, if my lord friend has any objection to it.
So you have to defend the impugn order?
Yes, madam. I'm appealing for respondent numbers 2 and 3. That is the Lok Ayukt.
Yes.
I will attempt to keep my submissions in response very short. The first response I'm extending, my lord, I'm raising the issue of locus of the petitioner. Petitioner, according to me, has no locus to file this writ petition. Why I say that is because of the impugn order itself, and which my learned friend has pointed out the specific para, that is para 3 at page 92. I'll read paragraph 3, my lord. The following facts are material for consideration of this matter. Respondent numbers 2 to 15 are contractors. They, being not government servants, do not come under the jurisdiction of the Meghalaya Lokayukta Act 2014. My friend is the petitioner is a contractor. Very clearly, according to Lokayukta himself, the petitioner does not come within the jurisdiction or under the ambit of the Lokayukta. Now, this fact has to be read in conjunction with the operative part of the order. So on the one hand, Lokayukta has said petitioner and other contractors do not come under the ambit of the Lokayukta Act.
Yes.
Having said that, what is the operative part of the order? Next page, if Lordship looks at, Lordship has already gone through it, but if Lordship allows me again, the second last paragraph, my lord, due of lack of jurisdiction over the non-government servant, persons like the contractors as mentioned earlier, and other legal hurdles. That means again, Lokayukta is saying I don't have jurisdiction over contractors. In the greater interest of public and for doing justice, it is directed that number 1, complaint petition be treated and registered as FIR under proper section of law and investigated by police, etc. So there is a direction to register an FIR and to investigate the matter by the police. Number 2, persons against whom prima facie case of misuse, etc. is found be brought to book and prosecuted. Second direction to prosecute anyone who might be involved in the scam, in the misappropriation, etc. Number 3, DGP Meghalaya shall monitor the investigation, the prosecution. Number 4, SP William Nagar shall inform the registry of the Lokayukta about the initiation of criminal proceedings within 10 days. Lordship will have to notice and Lordship will have to ask, how is the petitioner aggrieved by this order? Number 1, the order, the operative part does not name the petitioner, does not say register a case against the petitioner, does not say prosecute the petitioner, does not say anything of that sort. It is a general direction that register an FIR. The legality of that direction, I'll come to that later. But there is a general direction, register an FIR, investigate the matter. If you detect somebody has done misappropriation, prosecute that person. How is the petitioner involved? By filing this petition, is the petitioner admitting in a way that he is the one who is misappropriated and therefore he anticipates that there will be prosecution against him at some point in the future? It appears to be that way. Point is very simple, my lord. The locus of the petitioner is clearly absent from this writ petition. For a person to file a writ petition, the person has to be a person aggrieved. And there is extensive law on this point. Who is a person aggrieved? Person aggrieved, my lord, in very simple terms, is a person whose right has been taken away by a certain order or action, whose property has been taken away illegally, or who has suffered some illegality on account of the action or orders passed by some public authority, my lord. In this case, the order that has been challenged, has it taken away any right of the petitioner? Has it taken away any property of the petitioner? Has it committed any illegal infringement of any right of the petitioner? No. It is an order passed not in personam. It is an order passed in rem. It is a universally applicable order. The petitioner very clearly does not have any grievance that can be detected from this order. There is a general direction. Petitioner cannot assume that ultimately he will be found responsible, and therefore to nip the matter in the bud, he has come before this honorable court through this writ petition. Writ petition cannot be entertained in assumption. So the first request to this honorable court was is to kindly examine the locus of the petitioner. Petitioner, in my very humble submission, has no locus to agitate any of the grounds which he has agitated today before this honorable court. Number 1. Number 2, my lord, irrespective of the submissions that have been advanced, Lordship will kindly look at page 23 of the writ petition. Page 23.
Yes.
Now, page 23, towards the bottom, Lordship will see there are certain questions of law.
Yes.
Questions of law, my lord, that have been formulated by the petitioner. In total, my lord, there are about 7 questions of law.
Yes.
Now, I have filed a short affidavit, which is on record. I have addressed these questions of law, and I believe, my lord, I submit that these questions of law very well encapsulate the entire case of the petitioner. So, with Lordship's permission, I will address these 7 questions one by one, and at the end of which, I am confident that Lordship will see that there is no real case that the petitioner has to argue. The first question, if Lordship kindly sees, is number 1, does Lokayukta have the power to direct registration of FIR against persons not covered by its jurisdiction? In other words, has the Lokayukta, the question should be, has the Lokayukta in the impugn order directed FIR, registration of FIR against private people, private contractors? The order speaks for itself, my lord. I don't need to spend too much time on it. The order is very clear. The order is not for registration of FIR against contractors or any private individual. It is for registration of FIR per se, full stop. Ultimately, what happens, that is another issue entirely. But the direction in the impugn order is not for registration of FIR against any private persons who may be outside the jurisdictional ambit of the Lokayukta. Lokayukta himself admits that private contractors are beyond his jurisdiction. So the first question of law that has been formulated, does the Lokayukta have the power to direct registration of FIR? It doesn't have the power. But in this case, has it been directed that FIR should be registered against persons I have no authority over? No. There is a general, simple direction to register an FIR. Number 1. The second question, if Lordship kindly sees, the second question of law, if Lordship kindly sees, does the Lokayukta have the power to direct registration of FIR in light of law laid down by Supreme Court? Now, question has been framed, but what is this law laid down by Supreme Court? With all due respect, I am not sure, because no law has been placed as to on this point. But in any event, the question is, does the Lokayukta have the power to direct registration of FIR in light of law, etc.? To answer this point, my lord, if Lordship kindly looks at the Act itself, Section 20, subsection 3, that is at page 53.
Yeah, I can see here.
Yes, my lord. Page 53.
Okay. Yes.
Question, Lordship will kindly remember, the question is, does the Lokayukta have the power to order for registration of FIR? Now, 53.3 has been read by the petitioner, but with Lordship's permission, I'll read it again. Yes. A bench consisting of not less than 3 members, now it is 1 member, of the Lokayukta shall consider every report received under subsection 2 from the inquiry wing. So I'll just pause, my lord. It is important for Lordship to kindly appreciate that section 20, the entire section 20, the scheme contains or provides for 2 reports to be submitted. As soon as the complaint is received and the Lokayukta sees that there appears to be some sort of substance in the complaint, he orders for a preliminary report, first report. Subsequent to the preliminary, so once the preliminary report is submitted, section 3, subsection 3 comes in. Preliminary report has to be considered by the Lokayukta. Now, reading further, my lord, shall consider every report received under subsection 2, that means the preliminary report from the inquiry wing or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case and make recommendations to proceed with one or more of the following actions. Now, actions are, number 1, clause A, investigation by any agency, including any special investigation agency. I'll just stop. So the power that has been given very clearly under subsection 3 is, consider the report, the first preliminary report, If you think that there is some substance, then the power, the express specific power is order for investigation by any agency, including any special investigative.
This will be only vis-a-vis the public servant.
Absolutely. By the public servant. So it need not be mentioned that it is only against the public servant, but the investigation which can be ordered, investigation can be ordered under subsection A, subsection A. Now, my submission is that investigation in this case has been ordered by the police. Through the impugn order, police have been directed to conduct an investigation. Prior to that, it has been directed that take the complaint petition and register it as an FIR. Lordship will have to see, is there any real illegality with that direction? Taking the complaint petition and registering it as an FIR. Is there any illegality in that? I submit no, for the reason that police have been asked to investigate. Lordship will kindly appreciate any investigation by the police, the starting point of any investigation is always an FIR. The police cannot investigate in a vacuum. There has to be a complaint, an FIR registered. Complaint petition filed with the Lokayukta has been given to the police and told that this is your FIR, register it as an FIR and conduct investigation. So the second question of law which was formulated, does the Lokayukta have the power to direct registration of FIR? In this case, considering the fact that police have been asked to investigate, not some other agency, the police have been asked to investigate, there is no illegality or infirmity with the fact that FIR has, the complaint petition has been taken to be the FIR and FIR has been registered. As I said, any investigation by the police has to be based, the foundation of any investigation, the starting point is always an FIR. So the complaint petition has been taken to be the FIR. Question of law is answered very simply by stating that Lokayukta in this case, in the circumstances of this case, very well had the power to direct that the complaint petition should be treated as an FIR. Second question. The third question which has been formulated, if Lordship kindly goes back to page 23.
Yes.
Page 23, my lord, the third question. It is a question which has lost any force, and the petitioner will also agree. Do subsections 3 and 7 of section 20 of the Meghalaya Lokayukta Act mandate that the reports be judicially considered by at least 3 members, thus creating a right in favor of the accused? Lordship, the Act initially, when formulated in 2014, had said preliminary report and detailed final report have to be considered by a bench of 3 members. That was subsequently amended in 2019. Amendments were put to challenge before the division bench, which Lordship was a part of. Amendments have been upheld by this Honorable Court itself. My friend has fairly conceded that as on date, even on the date of the impugn order, on the date of passing of the impugn order, 1 member, that is the Lokayukta by himself, could have considered. So this question has lost flavor, lost any meaning, my lord. Moving on, my lord. Question 4 and 5 are fairly similar and connected. I'll read question 4, my lord. Does not the proviso to section 5 of the Principal Act inserted by Meghalaya Lokayukta Amendment Act apply only to the section and not to the entirety of the Principal Act as per the principles of statutory interpretation? Number 5, does not section 5 of the Principal Act envisage a very specific context of a running institution, etc., etc., my lord? The challenge in these grounds 4 and 5, the challenge in these grounds is regarding section 5 and the proviso that was inserted through the amendment of 2019. That, my lord, has extensively dealt with in the division bench itself. So I need not press this point any further.
What is the relevant
para 12 is where the operative part starts.
This is on question number?
On question 4 and 5.
4 and 5. Yes.
Question 4 and 5, para 12, my lord, there is no dispute that it was the state legislature which enacted the original statute in 2014, and such legislature had due authority to alter or amend the provisions thereof. Just as the state assembly deemed it fit originally for the lokayukta to be a body of several persons, it could have provided for a lokayukta to be a single person authority. There was neither any impediment at the initial stage. Lordship, I'll skip this part. Section 5 is relevant. They have raised the issue of Section 5 in questions 4 and 5. Para 13, my lord. Further, since the state legislature had due authority to amend its own act in such manner as it thought fit, the introduction of the proviso to Section 5 by the 2019 amendment would be all pervasive and cannot be said to be confined to Section 5 alone. This answers question number 4 and 5. Question number 4 and 5 is regarding the proviso that was inserted in 2019. The assertion in question number 4 and 5 is that the proviso, according to petitioner, applies only to Section 5 and not to the rest of the Act. That was answered by Lordship in the division bench, that it is all pervasive and cannot be said to be confined to Section 5 alone. So the proviso was that a one-member bench, even without appointments being made of other members, orders of the lokayukta will not be invalidated for that reason. So their contention was that this is confined only to operation of Section 5. It will not apply to Section 20 proceedings. Lordship in the division bench has said no, it applies to the entire Act. So questions 4 and 5 of the petitioner have been answered by Lordship himself through this order, my lord, para 13 of this order. Question 6 on page 24.
Yes.
Connected to questions 4 and 5.
Yes.
Question 6, for the above reasons, is not the order of the lokayukta dated so and so delivered by a single bench without jurisdiction? No. It is within jurisdiction, sitting alone without any members. Lokayukta had the authority after the 2019 amendment to have passed the impugned order. So this question need not take up much time. This question is linked to questions 4 and 5. Question 6 is, does the lokayukta sitting singly without any other members, does he have the jurisdiction? He has the jurisdiction. I believe petitioner has also conceded to that point. Last question is question 7. I'll read question 7, my lord. Is not the order of 26/2/2021 also violative of subsections 3 and 7, because at the stage of the submission of preliminary report, the lokayukta is supposed to first consider the report and give a finding that there is a prima facie case, and only then recommend investigation. Now this question, my lord, which has been framed, makes a reference to section 20 and what, according to the petitioner, section 20 requires. If lordship looks at section 20 again, subsection 3,
yes,
subsection 3, so first subsection, lokayukta can ask for a preliminary report. Subsection 2 says preliminary report to be submitted within 60 days. Once it is submitted, subsection 3 comes in. Subsection 3, if I'm allowed to read it slowly this time, a bench consisting of not less than 3 members of the lokayukta shall consider every report received under subsection 2 from the inquiry wing or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case, and this is very important, and make recommendations to proceed with one or more of the following actions, namely so and so. Now the contention of the petitioner is that in the impugned order, you have not, or the lokayukta has not recorded prima facie satisfaction. So without recording prima facie satisfaction, how could you have gone further and ordered whatever was ordered for? According to them, first prima facie satisfaction has to be recorded after, when you consider the preliminary report. My humble response to that is no, this is not true. If lordship sees what does the section exactly say? After giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case. It says decide and make recommendations, etc. Now, it does not say first prima facie case has to be recorded by the Lokayukta. It just says decide if there is a prima facie case. If you have decided, then you make recommendations. In the impugned order, there is no running away from the fact that there is no recording that yes, I decide or I hold that there is a prima facie case. It is not required to be recorded. The fact that recommendations have been made, I believe, is evidence enough of the decision that has been taken by the Lokayukta that yes, there is a prima facie case. So to read subsection 3 in the manner that is being suggested or requested by the petitioner would mean changing the language of subsection 3. Subsection 3 says first you decide and recommend. So that decision and recommendation has to be one action. It doesn't say you decide and thereafter you recommend. The interpretation of the petitioner requires reading a thereafter into subsection 3 that violence, my lord, cannot be committed on the statute. So that is one aspect. The other aspect is that this impugned order, is it really an order under subsection 3 or is it an order under subsection 7, my lord? Lordship will see subsection 7.
Yes.
A bench consisting of not less than 3 members of the Lokayukta, now it's 1, shall consider every report received by it under subsection 6. Now subsection 6 speaks of the second report, the detailed inquiry report. So shall consider every report received by it under subsection 6, that means the detailed inquiry report from any investigation agency, and may decide as to file charge sheet or closure report before the special court, etc., etc., initiate the department proceedings, etc., etc. Now in this case, it is important for me to humbly point out that Lordship, kindly look at page 74. Prior to that, 73, my lord.
Yes.
Page 73 is a letter from Shri So-and-so, Assistant Inspector General of Police to the Lokayukta. I'll read, my lord.
Yes.
With reference to the above, I am directed to enclose here a copy of letter dated so-and-so, along with its enclosures, being the detailed inquiry report conducted by so-and-so. Yes, ma'am. So this is the letter through which the second report, the second detailed inquiry report was transmitted. The previous page, my lord, page 72.
Yes.
Page 72 is the first order that was passed by the Lokayukta.
Yes.
I'll read, my lord, just 2 lines. Seen and perused complaint petition dated nil filed by Srimati so-and-so, advocate on behalf of complainant, register the case. DGP Meghalaya Shillong is directed to cause a preliminary inquiry and to submit the report within 4 weeks from the date of this order. What I'm attempting to stress on, what I'm attempting to highlight is that in this case, before the Lokayukta, there were 2 reports submitted, preliminary report and the final detailed inquiry report. The order in question, the impugned order, was passed after the detailed inquiry report was submitted. So if it is an order that is passed after the detailed inquiry report is submitted, what would be the procedure to be adopted? That would be under subsection 7, my lord. Secondly, I'll be required just for 2 minutes to refer to the merits of the order, the factual merits. Lordship, a lot has been made out of the fact that according to them, the inquiry report did not support the allegations. But what exactly did the inquiry report say? If Lordship looks at para 4 at page 92.
Page 92.
Yes, madam. The impugn order. So the petitioners, one of the legs of the petitioner's argument is that there was no material or there was no evidence on record to warrant or to justify any action being taken by the Lokayukta. Now, what is the finding of the Lokayukta, my lord? The second last line of para 4, if I'm allowed to read, my lord. The detailed inquiry report simply recorded in its finding that, as a result, rampant corruption and misappropriation of public fund by the contractors and officers of GHEDC in execution of projects 31-34 under William Nagar constituency, comma, I'll stop, my lord. So first, there is a finding in the inquiry, in the final detailed inquiry report, that there is rampant corruption in the GHEDC. Second part is, the evidences on record did not substantiate the allegations made. So on the one hand, inquiry officer says there is rampant corruption. On the other hand, he says that the evidences on record did not substantiate the allegations made. Now, there is a contradiction. On the one hand, you say
the inquiry report.
Yes, the detailed inquiry report is.
You have filed it with your affidavit.
It's in the writ petition. That's at Annexure 4.
Okay. But you said that you don't have the report.
No, the full report, my lord. There are two inquiry report, my lord. One is the preliminary inquiry report. Another one is the final inquiry report.
So the final is on record.
Final is on record. Preliminary report, my lord, on the basis of which, my lord, they have asked for the second inquiry. That is not before us, my lord. That is with the Lokayukta, my lord.
That is not relevant also for the moment, because my friend is focusing on the detailed, the final report.
Yes.
So the final report, my lord, as I was trying to highlight, there was some contradiction in the report itself. On the one hand, he says rampant corruption is there. On the other hand, he says no evidence on record. So, irrespective of that contradiction, Lordship will kindly turn the page in the impugn order itself.
Yes.
The Lokayukta has attempted to itself understand what is the position, my lord. Second paragraph itself, nothing is found as to whether the authority submitted utilization certificates for the balance amount of so and so. No explanation is given for non-submission of utilization certificate for the said amount. From the inquiry report, it does not appear whether the work orders were issued to the contractors with the approval of the district council. Records do not reveal how the project's plans were prepared so as to verify the manner in which selections were made or whether the government instructions were followed or not. Coming to execution of works, it is revealed from the inquiry report that in many schemes, plans, changes were effected without disclosing any reason. Transparency in the matter of selection of contractor party seems to be not maintained. There are other things related to execution of work which could not be examined by the inquiry officer. This could be possible. So it goes on. Point is, my lord, Lokayukta, before passing the directions that were ultimately passed, applied its own mind to the contents of the report and came to a finding that there are many gaps in the report itself. There are many gaps. Certain things have been left unexplained. Certain things have been explained to the detriment of the GHEDC officials. In that background, my lord, these directions were passed. Going back to my first point, how is the petitioner affected by these directions? There is no possible way in which the petitioner can be affected, can be said to be aggrieved by these directions. Petitioner has not filed this by way of in the shape of a public interest litigation, being a public spirited individual that public authority, when passing this order, needs to conform with the requirements of law, etc. He has filed it in a personal capacity. In a personal capacity, how is the petitioner affected? He is not affected, very clearly, my lord. Secondly, the 7 questions of law which have been formulated have been answered in my affidavit in opposition. When passing the final order, I'm confident the Lordship will take the trouble of going through the affidavit in opposition. There may be certain gaps in the submissions which I have advanced today. With Lordship's permission, I will take the liberty of placing 2 judgments, if Lordship allows, by tomorrow itself, on the issue of locus, my lord, on the issue of the locus of the petitioner, as to how or who is a person aggrieved and how the petitioner cannot be said to be a person aggrieved. I'll place it tomorrow, if Lordship allows.
Fine.
That's okay.
My lord, I am appearing for the state in this matter. And my lord, in the connected matter, my lord, because same order is under challenge by state in the connected matter, my lord.
Connected
And
matter.
the state has also challenged this order of direction by Lokayukta to register the FIR, my lord.
Okay.
And the commission of the state is confined to the jurisdiction of the Lokayukta to direct registration of FIR under the Lokayukta Act, whether Lokayukta has the power to direct registration of FIR or not, my lord.
I think that
so
is
any hearing
that is the same issue that is being discussed here.
Yes, my lord. This is the same order. So this is the same order. What I was praying, my lord, because whatever decision your lordship is going to render in this matter will have some bearing in the other matter, my lord. So what I was praying that if both the matters can be heard and the question of law is decided by your lordship, there will be clarity, because I will be taking legal ground. I will not be going into the factual dispute between petitioner and the private complainant, my lord. While only my endeavor would be to assist the court on the question of law, my lord. So therefore, I was saying that if 2 matters are taken up, because I have already prepared a judgment compilation in the other matter. And here it's a question of law whether Lokayukta under Lokayukta Act has power to direct property. Aware power to direct FIR is either with the police under 156(3).
When is the other matter? When is the other matter fixed?
Lordship, I'll just quickly respond to that. This prayer was actually made previously also. In today's matter, this prayer was made that both matters should be tagged together. For some time, they were actually tagged together. They were traveling together. Then, at some point, in the other matter, in Learned AG's matter, where he's the petitioner, in that matter, my Lord Justice, thank you, has passed a specific order that both matters are not similar and they should be detagged. So there is if I can finish, there is a specific judicial order detagging the matters.
It doesn't matter. You see, it doesn't matter. You see, even if the matter is detagged, what happens is, even if it is heard simultaneously, or rather one at a time, on the same day, if there are similar issues involved, which this court has to adjudicate upon, and if one decision, if decision in one case affects the merits of the other case, then
Lordship,
there's nothing to it.
Lordship, I would normally agree with my lord, but what I was highlighting is that there is a judicial finding that matters are not similar.
There is no judicial finding. Those are interim orders passed. There is no judicial finding. Those are interim orders passed. And what I am praying is that the issue is one common. It has to be heard.
If I can place the order. If I can
even then, see, there is no bar for this court to hear the matter.
But matters are traveling
and to decide.
Very well. Matters are different stages. What is happening is this is today. This matter is at the final hearing stage. The other matter, Lordship will kindly recall, Learned AG has raised the issue of my locus. So he has to file a petition.
And it was vice versa.
Yes, my lord.
And we have to file it by 14th. We have to file it by 14th, my lord.
So he has to file a petition to delete me as a party, etc. So matters are at different stages. So to tag them together would just mean a delay of, especially this matter, which is ripe for consideration.
The issue is, my lord.
So if Lordship,
issue is, my lord, common. Issue is common, my lord.
If Learned AG is taking the same submissions, he can make the same submissions today itself in this matter. Whatever he has to submit, whatever he might have submitted in the other case.
So because now, so then therefore both the matters have to be heard together. What?
But matters are different.
Both the matters have to be heard together. And the order is common. Order is common, my lord. Order is common. Whether Lokayukta has the power to direct the registration of a FIR under Lokayukta Act or not. This is a question. Whether Lokayukta can defend it.
So this impugn order here is also a subject matter of that.
Yes. So in that case, in the other one, state has challenged that.
We are not talking about the stage.
No. In the other one, the state, the state government has challenged.
I understand.
Yes.
if I recall,
the order is the same.
if I
Obviously, the
recall
order is the same.
correctly,
Order is the same.
we are still on the issue of maintainability and locus and all those things.
In the other matter, my lord.
In the other matter.
Yes, ma'am. Yes, ma'am.
Whereas here,
we are at the final
we
stage.
are already discussing the.
That's why I was requesting. That's why I was submitting that let the submissions be made today. Whatever he has to say.
Your Lordship, I have no difficulty. So far as locus is concerned, in this case also, Lokayukta has no locus, but I am not on that issue. Only on the issue, my lord, whether Lokayukta has power under Lokayukta Act to direct the state government to register FIR. Whether Lokayukta jurisdiction extend to Garo Hill Autonomous District Council or not also, my lord. That is also issue which I figured out recently, my lord. Lokayukta has no jurisdiction so far district council are concerned, my lord.
See, that is exactly what is in the mind of the court. See, as far as the, the law point is concerned, that would be the only issue to be decided.
Absolutely.
As to whether the
Yes,
can exercise its power, as has been, seen in the impugn order.
Yes.
Yes.
Particularly
Yes,
the latter part of the order.
Yes, sir.
That is the question.
And the issue is common in both. Issue is common in both, my lord. To that extent, the issue is common.
So what we can do, what we can do, Mr. Kumar, without going to all the formalities of the other case, we can we can place the matter, side by side, and take up.
Yes, sir.
And take up.
Yes, sir.
We'll complete.
I'm deeply obliged.
We'll complete with
I'm
this.
deeply obliged.
We'll hear. See, the court will hear you on this issue first, on this rather in this case first.
Yes.
And then
yes, sir.
If it, if it's
yes, sir.
Really,
because the issue is common. I have no.
Yeah, if it's really necessary to go into the facts of the other case.
So if Lordship is inclined to...
the facts are not required to be gone into. With respect, I will say that facts are not required because only legal issue.
If Lordship is inclined to be to take the matters together, very well, my lord. But Lordship, there may be an observation that the hearings are to be conducted independently.
No.
Because it should not happen that this case lingers on.
There will be no such observation. The only thing is this, matter can be placed together. What I'll do is today, matter is adjourned. We'll list the same on the, I will list this case on the day the other case
Other
is
matter
listed.
is listed.
Submissions cannot be similar
for
the reason that their learned AG is petitioner. So naturally the direction of the submissions is different from the direction it would be as a respondent, which he is today.
Yeah, that will be considered in its own,
matters have to be taken independently. That's all I'm requesting.
Its own peculiar nature.
Yes, ma'am.
That would be.
Yes, ma'am.
But the only thing is that, again, the peculiarity of the whole matter is that it is the same impugn order that is, the focus in both petitions.
What I could have understood, my lord.
Yes.
Learned AG is also on the same issue where I am, my lord. He is on the as a state, my lord. He is challenging the order. I am challenging as a contractor, my lord. The issue which has to be decided by my lord is the same, my lord, and it is the same impugn order. That is my understanding, my lord.
Only thing is, this court will not,
yes, sir. So both the matters can be side by side. There is no problem.
Make any comments on that, but the fact remains that if there is any pilfering of any public, money for that matter,
it comes down to that.
PCA Act may come into the picture and all those things.
Now, if
that is a different aspect of the matter.
But if that is the case, my lord, then 156, my lord, whether Lokayak has the power under 156 of CRPC, that also has to be examined by this honorable court.
I'll answer that.
Yes.
If that has been raised, I'll answer that.
So we'll keep this matter as part heard. And when is the date of the?
I'll give the date, my lord, to the court master. I'll give the date, precise date of the order, last order, and it will be listed on that day only.
6th of September, so Maran has given 2 weeks time. So probably
Yeah, I'll check the date.
20 or 21.
What is the case number? The other one?
Case number is WPC number 363 of 2021.
September.
21st then.
21st.
Yes, Lord. I agree.
This matter has been heard partly on the petitioner having concluded his argument, and the respond in part by the respondent number 1. You are 1 and 2.
2 and 3.
1 and 2. on respondent 2 and 3. On pre-meet with the parties, this matter is adjourned. List the same on 21st. 21st.
Obliged.